The last time I had the pleasure of being physically in your green and pleasant land for a talk like this, I began by saying that maybe we had helped you lot a bit late in World War I and World War II, but you sure helped rescue our country in the Guantanamo cases in our Supreme Court, and I'll be telling the story of those cases in a few minutes. And I'm delighted to be able to be doing that in a session with Professor Endicott, because after those cases came down, he wrote a very helpful article called Guantanamo, The View from Abroad. And the suggestion of my remarks today, which are being presented on the eve of VE Day's 75th anniversary, and at a time when both our political systems have been under very serious stress for some years, is that perhaps we on our side of the pond have some resources that will enable us to return the favor of the Guantanamo cases. And after I'm done, I hope that Professor Endicott, who's the author of a more recent piece called Don't Panic, will tell us in his comments whether my suggestion is one that should cause panic on your side or will instead help lead you to sunlit uplands. My plan is to say a few words about the future of the British Constitution as it may emerge from our common history, with a focus on civil liberties. And then we can all exchange thoughts so that I can exploit your ideas in a much bigger piece that I'm working on about the future of the British Constitution in a whole variety of areas not limited to civil liberties. But to focus there, as you know, in the wake of Miller 1, Lady Hale made several speeches in which she said that that was an easy case because there parliamentary supremacy was being enforced against the crown. But she said, we don't have any basis for exercising a judicial review that might invalidate acts of parliament. And I know that her view that you don't have judicial review in the American sense, judicial review that will work against legislation, has generated much comment on your side. But let me give you, Lady Hale, the view from abroad. I would respond to her statement that you don't have judicial review in the American sense with three thoughts, which I'll try to give you in compressed form so that I can stick to my allotted 30 minutes. And those three thoughts are, yes, you do. And that's what we benefited from not so long ago. Two, America didn't originally have judicial review in the American sense either, but it developed overcoming a number of critiques that may have analogies on your side. And three, I'll end with a few tentative ideas on what your judicial review might look like with respect to civil liberties specifically. So, number one, yes, you do have judicial review, and under that heading, past, present, and future. As to the past, keeping Parliament under control is hardly a new problem. And when, quite recently, there was a great deal of creative writing over there about how to interpret the Kinnock Amendment to the Benn Bill, well, that writing was all based on very old rules of statutory interpretation, which has been a tool of judicial control over Parliament for centuries. Dr. Bonham's case in 1610, before it ever got to the contested dictum about a statute against common law being void, gave a whole series of examples of construing statutes with greater or lesser degrees of plausibility in favor of the liberty of the subject. And in particular, habeas is a field where we get lots of judicial imagination, perhaps because originally we have King's Bench self-interestedly asserting its power over other courts, But that soon extends to neighboring legal contexts. For example, we have the fiction, since the king wants the law to be observed, the judges are obeying his will when they rule that something that an officer has done is illegal, even though what the officer did was in accordance with statute or actually what the king, the real human being, wanted. Or some action is contrary to equity, regardless of statute. And all of that assumes that the judges don't just declare the statute void, not invalid, just never had any legal existence to begin with. For example, I think we can safely assume that if Parliament passed a criminal statute saying that it would not be subject to royal assent, and it did not gain royal assent, then if some individual were prosecuted for violating the statute, the judges in any era would have liberated the individual because the statute never had any legal existence. And Miller, too, whether correctly or not, applies that very framework in saying that an order in council proroguing Parliament never had any legal existence. In fact, in argument in the Miller 2 case, counsel for the Prime Minister made exactly that analogy and said to the court, you would hardly look into a royal assent, would you? And although the inference isn't inevitable, it seems to me that the answer contained in the opinion, silently, is yes, we would. And speaking more generally, my perspective on that opinion is that it fits within a historical framework in which the judges' essentially independent control of their own powers excuse me, has been in existence since the Restoration. In particular, King's Bench has had inherent habeas powers since the 1600s, and Parliament's intermittent efforts to get involved there have been brushed aside, as Paul Halliday has shown in detail in his terrific book, by judges whose view has been that they have their inherent common law powers plus any that Parliament might grant, not except as may be restricted by Parliament. And the citation is page 175, note 23 of my new book, available for purchase by clicking through the link for this event. So now, switching over to United States in 1807, a compression of the story that I tell in chapter 13 of the book. Several people have been arrested in connection with a treasonous conspiracy led by former Vice President Aaron Burr, who has decided that it would be a good idea to travel west, having just killed Alexander Hamilton in a duel. And so the people arrested in this conspiracy seek habeas corpus from a lower federal court, and when that fails, from the US Supreme Court. Now, there is a statute authorizing the Supreme Court to grant writs of habeas corpus, but it is written in the exact same terms as the one that same court just 3 years earlier in our famous Marbury versus Madison case had declared unconstitutional with respect to writs of mandamus. So, counsel for the prisoners argues on the basis of English authority that regardless of whether you have statutory power to issue the writ, it is an inherent part of your judicial power to do that. And he says, quite accurately, that all superior courts of record in England, whether or not they had any criminal jurisdiction or statutory habeas jurisdiction, quote, are invested by the common law with this beneficial power as incident to their existence. And he pointedly asks whether the American people had not as good a right as those of England to the aid of a high and responsible court for the protection of their persons. And to this, Chief Justice Marshall responds with some holding and some dictum. The holding is that the statute, in fact, gives us the power to issue the writ, which we accordingly do. The dictum, made up for political reasons that I detail in the book, is that we would lack the power if a statute did not exist. Quote, courts which originate in the common law possess a jurisdiction which must be regulated by the common law, but courts which are created by written law and whose jurisdiction is defined by written law cannot transcend that jurisdiction. Therefore, although responding to a series of problems that had been revealed during the course of the American Revolution, our Constitution limits suspension of the writ of habeas corpus. Congress could suspend the writ by doing nothing at all. If it didn't grant any court the statutory power to issue the writ, the privilege itself would be lost, although no law for its suspension should be enacted. Now, fast forward to the Guantanamo cases in which you lot helped civil liberties prevail, not once, but several times. The very federal habeas statute that John Marshall relied upon is still in force. And the Supreme Court first decides that it covers the prisoners at Guantanamo, Rasul versus Bush in 2004. And then Congress tries to change that result by statute, but the court construes the statute to say that it applies only to future prisoners, Hamdan versus Rumsfeld in 2006. So Congress passes another statute that says, we seriously mean this. No court, justice, or judge shall have jurisdiction to hear or consider an application for a writ of habeas corpus filed by or on behalf of an alien detained by the United States who has been determined by the United States to have been properly detained as an enemy combatant or is awaiting such determination. So in challenging that, the petitioners were seeking an outcome flatly contrary to statute and the will of the executive branch in a situation where John Marshall had said explicitly that Congress was supreme. The US Constitution needs help. And in the end, the prisoners won the case, Boumediene, in 2008, by saying the statute doesn't matter. Habeas corpus is an inherent judicial power. Look at the many well-documented briefs filed by our British cousins and their cousins from common law jurisdictions around the world who collectively formed a truly impressive expeditionary force. And it's not difficult to see the strategic plan guiding the campaign of those forces. The prisoners were appealing to the self-interest of today's judges in maintaining their independence as a power center and justifying that by arguing that this independence had been built into the original architecture of the system. And the plan worked. The court relied heavily on the history, observed that the other branches are just the ones to be constrained and shouldn't be able to control the writ, and silently overruled John Marshall, details to be found in chapter 15b of my book. Turning to the future, We on the American side will have to make sure things stay that way. Boumediene was a 5-4 decision. It was poorly received in conservative circles. The lower courts criticized it publicly and defied it. And the new justices on our Supreme Court are strongly inclined to defer to the executive on terrorism. And in remarks likely aimed at those justices, Attorney General Barr attacked the Boumediene decision at length and in strong terms in a speech last fall to a leading conservative group. On the other hand, in some circumstances, notably ones dealing with the run-of-the-mill petitions for release brought by state prisoners, we may benefit from exploiting a new interest among the justices in the original distribution of judicial power between the states and the federal government, which has been obscured for over 100 years, but which a new case may enable us to dust off. And I have an article on that case, which is cited in the middle of the slide, that I'll be happy to share with people. And the basis of this idea is the supremacy clause of our Constitution, which says this Constitution and the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Now, this, of course, is an invalidation of subunit laws inconsistent with superior law, but as has now been reiterated in the Montgomery case, it is also an affirmative mandate that the subunits enforce the superior law. That is, states have to entertain federal claims as a matter of constitutional law, even if federal statutes might restrict the federal courts from doing so. More to the point of your situation, the supremacy clause also, by negative implication, gives some powers to the subunits that I'll come back to in my third section. But first, my second response to Lady Hale. We didn't originally have judicial review in the American sense either, but as the North American colonies evolved from a system in which there had been Privy Council review of colonial legislation, the American system developed, overcoming a number of critiques that may have analogs on your side. Let me start with the institution of a popular referendum binding on the legislature. And that, of course, is a novelty over there that has spurred lots of discussion about how it's to be reconciled with parliamentary supremacy. Well, it was a novelty in the US too at one time, and our Supreme Court dealt with it in the Pacific States Telephone Company case in 1912. That was during our populist era, in which reformers on the state level were trying to wrest control of lawmaking from legislatures, which they saw as being in the pockets of this big business. So in this particular case, they enacted a tax by ballot initiative. And the taxed corporation said, this is a violation of the Republican form of government clause of our Constitution, which says the United States, that is the federal government, shall guarantee to every state in this union a Republican form of government. And the corporations argued that direct lawmaking by the people, as opposed to their elected representatives, isn't what is meant by a Republican form of government. And our Supreme Court rejected the attack by saying that it presents a political question. Enforcing that guarantee is the domain of Congress, not this court. In other words, the people are entitled to get what they want. Now, our political question doctrine dates back to John Marshall and the very beginnings of judicial review. In Marbury versus Madison, he wrote that when the courts are called upon to act in cases in which the other branches have been invested by the Constitution with the power to act in their discretion, nothing can be more perfectly clear than that their acts are only politically examinable. But where a specific duty is assigned by law and individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured has the right to resort to the laws of his country for a remedy. On the other hand, questions in their nature political, or which are by the Constitution and laws submitted to the other branches, can never be made in this court. Now, at the time of the Marbury opinion, the popular consensus was hostile to the idea of judicial review because it was seen as an undemocratic overriding of the will of the people. And as an interesting aside, one reform that Chief Justice Marshall promptly implemented to combat the institutional weakness of his court was to end the English practice of judges delivering their opinions seriatim, but he had them all speak to through one single opinion of the court, which the judges had worked out through discussion, and he then delivered. And in this and other respects, my suggestion to you is that next time one of you is asked to write one more article for the popular press comparing Lady Hale to Justice Ruth Bader Ginsburg, you might do as well to propose one comparing her to Chief Justice Marshall. Now, in the context of its time, John Marshall's statement in Marbury about political questions reflected the weakness of the judicial branch. It was an assurance that the judicial branch would not meddle in questions that should be left to the democratic process. Actually, it was an assurance inserted as dictum into the case because the actual holding was that the question presented by Mr. Marbury was not a political question, but a legal one. And as the political question doctrine has evolved over time, it has been frequently used to enhance the court's powers rather than limit them. The interesting cases are the ones in which it is held not to apply. For example, the court has long adhered to the rule that it will not invoke the political question doctrine where personal liberties are at issue, or where, although politics are legitimately involved in the challenge decision, the right of the people to govern themselves is threatened. And this last rule was established in the case that the great liberal Chief Justice Earl Warren considered the most important one of his storied career, Baker versus Carr in 1962. That case refused to apply the political question doctrine to a situation in which incumbents were entrenching themselves by adhering to an archaic system of districts that over time had come to grievously violate the principle of one person, one vote. In short, rotten boroughs. And the reasoning of Baker versus Carr, which was intensely criticized by politicians, but which received broad popular support and is now a firm part of our legal system, is closely analogous to the one for which Miller 2 has been criticized. In order to ensure that the people were not shut out of the ability to make their voice heard, our court took cognizance of a decision which had been previously relegated to the political process. It made the judgment that under these particular circumstances, the political process was itself being undermined and could not serve as an effective check on the legislature. The reasoning was that no matter how loudly the public might shout that the legislature was malapportioned, one could hardly expect the incumbent legislators to fix it. So people thinking about the future on your side might find that there is ample material to exploit in the way in which our political question doctrine has evolved. And that bit of legal doctrine is part of a broader story. Chapter 14 of my book summarizes various reasons why our judicial review in the American sense, which was originally seen as undemocratic, came to be established over time as an entirely legitimate constraint on legislative supremacy. In particular, one of those reasons was a feeling that legislative supremacy is dangerous where the legislature is systematically failing to reflect public opinion. And looking at Britain, I think it's fair to say throughout the Brexit saga, it was difficult to find many members of the public who thought that Parliament represented their viewpoint, regardless of what their viewpoint was. And without getting too deeply into your politics and saying nothing about the crack up of ministerial responsibility or about the Fixed Term Parliament Act, it is certainly a fact of our history that to the extent incumbent legislators get to entrench themselves, judicial review gains legitimacy as an expression of the people's will. And as you all know much better than I do, for a long time, no one really focused on the extent to which so much of your recent legislation has in fact consisted of delegations to your administrative apparatus, nor on the fact that all cabinet ministers are also privy councilors, and in that capacity, they can make orders in council, which of course is actually an exercise of prerogative power. But now that the court is policing that power just at the same moment people are feeling a particular inability to control the government through their representatives in Parliament, you have the makings of potential long-term changes. At least until the coronavirus began monopolizing public discourse, I think it's fair to say that large parts of the UK electorate as a whole were feeling deeply frustrated. Not just we had a fair go and lost, but we'll get them next time, but rather this system is rigged, so rigged, in fact, that perhaps we need to rethink this whole United Kingdom project. And historically, periods like that are when, on our side, people have turned to the Supreme Court, and is how we involved over time the distinction between separation of powers, which you had, and checks and balances, which you didn't. See chapter 11 of my book. So as some British commentators have noted, the current frustrations would seem to put your court in a good position politically for the short term. And my suggestion would be that as it considers the longer term, your court may have good reason to delve into our experience. In our case, judicial review hasn't worked out very well when the public has responded to political dysfunction by taking big steps. I'm thinking about our Dred Scott case in 1854, in which everyone wanted the US Supreme Court to decide about slavery, which was tearing the country apart. And the effect of trying to solve that intractable problem in one blow was to hasten the coming of our Civil War and ultimately necessitate a basic rewrite of the architecture of our Constitution. But our judicial review has worked fine when the Supreme Court has been able to nudge the political branches along one slow step at a time, as with our civil rights movement that resulted in a whole series of small bore cases before Brown versus Board of Education was decided in 1954 in a unanimous opinion decided by that very same Chief Justice Warren who brought you Baker versus Carr. So, my third topic. In a period when the whole UK project is under stress, what might your evolution to a more American system look like, bearing much in mind that, as shown by your recent El Ghazouli case about sharing information with the Yanks in support of a capital prosecution, your Supreme Court will always remain open to arguments based on the evolving common law, regardless of how it decides any particular issue on any one particular day. Now, in the civil liberties area, our states must provide at least as much protection as the central government mandates, but may provide more under their own constitutions. That is the implication of the supremacy clause that I said I would return to. Historically, this has been important in two ways. One is increasing local autonomy and providing a safety valve when particular states think that the Supreme Court has not been sufficiently solicitous of civil rights, which happened most recently in the field of gay rights, which had traction in the states beginning in the 1970s, which gave much greater protection to a large swath of the population than the US Supreme Court was willing to recognize under the federal Constitution. And the second importance of this implication of the supremacy clause is that it gives the Supreme Court a comfort level when, in the course of expanding civil liberties under the federal Constitution, it's able to say that the states have already done so under their own constitutions. That happened in gay rights and has been a recent feature since the 1980s in death penalty cases, but it goes back into the 1950s and 1960s in such areas as the right to counsel. As far as I can see, a desire of the regions to provide greater civil liberties than the national government is willing to accept has never been an issue on your side, because the national government has been subject to controlling human rights regime from Europe during all of the period that the devolved parliaments have existed, and the regions have been content with those protections. But perhaps in the future, one could see the regions being unwilling to rely on the center's vague norms or rebelling against its actual retrenchments of civil liberties and wanting to enact more rigorous local statutes. And perhaps the immediate reaction would be that this would be entirely unprecedented in the British context and would involve the exercise of local legislative authority over areas not specifically devolved. Perhaps. But perhaps the problem could be handled in the UK by analogy to the way it's been handled in the US. Perhaps the UK Supreme Court could rule that the unwritten British Constitution has an unwritten supremacy clause that the Crown and its judges have insisted on since the conquest. The common law is the supreme law of the land. The regions are free to expand common law individual liberties in areas like right to counsel, protection against improper interrogation and self-incrimination, double jeopardy, but not to constrict them in violation of common law or applicable statutes. In the language of your current commentary, that would be cementing the Westminster as opposed to the Whitehall view of the British Constitution. But it has far deeper roots than that. In fact, I was actually able to obtain a royal warrant in support of this idea of declaring supremacy of the common law. Thank you, and I look forward to the day when I shall to thy happy coasts repair.
There we go. Thanks very much indeed, Eric. That was really interesting. I'm going to turn to Timothy for a response.
Thank you so much, Kate. Oh, I'm so proud of myself. I think I've unmuted myself. Good. Eric, thank you so much for coming over here virtually and discussing these things with us. There's too much to talk about. I've had the pleasure of reading Making Habeas Corpus Work, Eric's book that he mentioned, and I recommend it, and it means that I must restrain myself to fit into 15 minutes or so. And for that purpose, I thought I would just focus on a couple of things in what Eric has said today, but I'm not going to restrain myself altogether from asking at the end about what on earth is going on in Guantanamo Bay in 2020. But I think it's fair to raise that because it relates to some of the issues that Eric has raised today and that are all through his book. Think about the title, Making Habeas Corpus Work. He's not interested in forms and appearances, but in what actually happens. And one take-home message that I wanted to offer you from Eric's work on habeas corpus is that that's the thing about habeas corpus. You know, why in 2020 is it the only writ for which lawyers in this country still use the Latin? Well, that's because of the hype and the tradition and our inflated self-regard as common law lawyers. We like the Latin, but there is something distinctive about habeas corpus that justifies some of the hype, and that is that it functions, and Eric's work highlights that. So we want to make it work. Now, and Eric suggests that, and this is the first thing I want to talk about that he said this today, that we might well develop judicial review of legislation, and in fact, we've already got it. And this is really intriguing, and I think there's a lot to what Eric says. I don't quite agree when Eric suggests that the techniques of statutory interpretation are effectively or functionally judicial review of legislation. And I'll have to come back to that. But there certainly is something to what Eric says. We have a long tradition in this country, in England, of viewing statutes as void if they are contrary to, well, not only to human rights, but to reason in general. Here's Christopher St. Germain in the 1520s, wonderful scholar of the common law. If any statute were made directly against the law of God, the statute were void. There you go. A statute is void. He has an example, a statute prohibiting giving of alms. Prohibiting giving of alms. That statute would be void. Now, he didn't tell you how to bring judicial review proceedings against a statute, but Eric mentioned Dr. Bonham's case, and Cook knew how. When an act of parliament, says Cook, and this is in 1609, is against common right and reason or repugnant or impossible to be performed, the common law will control it and adjudge such act to be void. So there you go, come to the common law courts and we will adjudge an act to be void. It was around the time of Blackstone that we lost hold on this doctrine of judicial review of statutes. He himself, Blackstone, said that it's widely considered that acts of parliament contrary to reason are void. But, says Blackstone in the 1760s, if the parliament will positively enact a thing to be done which is unreasonable, I know of no power that can control it. And in particular, you shouldn't be able to go to the common law courts to get a statute held unlawful, because that would set the judicial power above that of the legislature, which would be subversive of all government. Well, there you go. That around his time in the 1760s, it was controversial, but he was prepared to state it as the doctrine of the common law that judges had no jurisdiction to hold statutes to be unlawful. And very soon after Blackstone, that's very clear. I mean, I won't spend the time going through the law. Judges cannot strike down statutes. And that's still the law today. Eric mentioned that Lady Hale has said things to that effect. Mind you, first of all, there is something to what Eric says about interpretation of statutes. Let me mention briefly a 2019 case in which the Supreme Court of the United Kingdom held that a statute that provided that there was to be no judicial review of the decisions of the Investigatory Powers Tribunal did not have the effect of preventing judicial review of the decisions of the Investigatory Powers Tribunal. And you can see Eric's point there. Well, that's very much like, it's very much like a judicial power to nullify a statutory provision. Now here, Baroness Hale in that case agreed with Lord Carnwath and one other judge, and Lord Carnwath said, although it is not necessary to decide the point, so this is just obiter, binding effect, this is, he says, I see a strong case for holding that consistently with the rule of law is the thing, binding effect cannot be given to a clause which purports wholly to exclude the supervisory jurisdiction of the High Court to review a decision of an inferior court or tribunal. You see what Lord Carnwath is saying? Binding effect cannot be given to a clause. That clause, that's a weasel word. He means a statute. He means an act of parliament cannot be giving binding effect if it excludes the supervisory jurisdiction of the High Court. In 1528, the worst thing that Christopher St. Germain could imagine was a statute prohibiting the carrying out of a Christian duty of charity. And he says that would not be a statute. In 2019, Lord Carnwath, the worst thing he can imagine is Parliament trying to prevent judicial review. And that would not have binding effect, he says. It's only obiter Lady Hale agreed with him. Now, that's not interpretation, that is judicial review of legislation. But it's a minority view. It's a minority view among the judges. The majority in that case used interpretation to give no effect to what Parliament had done. And there you might say, well, Eric's right. We've got judicial review. We just don't call it that. Functionally, it's judicial review, courts nullifying a statute. Formally, it's interpretation. But let's see through the appearance and see the reality. Well, my main point here is, by all means, let's pay attention to the function. But the function of a doctrine of interpretation is strikingly different from the function of a doctrine of judicial review of legislation. In this country today, if you love parliamentary supremacy, the protection for it is that the judges, if they're not going to give effect to a statute, must find a way of seeing what they're doing as giving effect to the statute. I'm not saying pretense. You can imagine judges pretending. judges must persuade themselves that they're not acting contrary to the will of Parliament, and must explain that why they're not in their reasons for decision. This makes a profound difference to legal advocacy seeking to avoid the effect of what Parliament has done. And it makes a significant difference to the judicial action to decline to give effect to a statute. The fact that they have to present what they're doing as interpretation. And they're not just pretending, in my opinion, they have to understand it themselves as interpretation. That has a very significant effect, practical effect. And imagine instead that the judges unanimously adopted that obiter dictum of Lord Carnwath that Lady Hale agreed with, and decided that they would not give binding, and had a doctrine that they would not give binding effect to legislation that is inconsistent with the principle of the rule of law. The practical effect would be radically different, because advocacy would be directed to identifying a ground of invalidity of statutes in the rule of law, and it would create something very much like a Bill of Rights, based on what Sir Edward Coke called reason, and what Christopher St. Germain called the law of God, and what the judges of the future might call the rule of law. That would be a radically different approach to the effect of legislation in this country. Second thing I wanted to comment on and ask Eric about is the role of democracy in judicial review of legislation. I was really interested in what Eric said about, and remember, this is the part of his presentation where he points out the evolution in America, an evolution that we might undergo in this country, from distrust and distrust of judicial exercise of power against the will of the people, towards a view, and of course it's controversial, Americans disagree with each other, but towards a fairly widespread acceptance of the legitimacy of judicial review of legislation. Now, I'm really interested in this because it seems to me that democracy can be a good reason for judges to interfere with legislation, and Eric pointed out how it might be. It might be where the act of a legislature damages democracy. I think there's an analogy here with habeas corpus. Does habeas corpus protect democracy? Well, of course it does, because it gives a terrifically effective way to get your client out of prison if he or she has been thrown in prison because the government is trying to prevent your client from criticizing the government. Habeas corpus is a protection for democracy. But it's not just a protection for democracy. And look at the Guantanamo Bay cases, which I'll come back to. That's not democracy. That's not democracy when in Boumediene, when the Supreme Court of the United States says that they can bring a petition for habeas corpus in the federal courts. They have, the detainees in Guantanamo Bay, they have no democratic rights in the United States. It's not a matter of the American people governing themselves. Habeas corpus to prevent the government from imprisoning its political opponents. The Americans need that if they're going to govern themselves, if they're going to have a democracy. Now, in the cases where habeas corpus protects democracies, there's also a tension, because in a sense it's anti-democratic if a democratically elected legislature wants to authorize arbitrary detention. There's a tension in the idea of democracy. And likewise with civil rights, human rights, freedom of expression litigation. What if it's a democratic initiative that is interfering with democratic processes. There's a tension in the idea of democracy. But now imagine democratic initiative to arbitrarily detain aliens. There's no tension in democracy here. Habeas corpus against such a measure is anti-democratic and required by respect for the humanity of the person subject to detention. The reason for habeas corpus in Guantanamo Bay is not democracy. Now, Eric, in your presentation, you said that you suggested that the move from distrust of judges interfering with legislatures towards acceptance of it as legitimate, you suggested that this reflects a realization that the American people might need judicial review of legislation to preserve democracy. But I wondered if you would agree that the legitimacy of American civil rights jurisdiction in the courts, and habeas corpus in particular, its legitimacy is not based only on democracy. I think there's more to the legitimacy of judicial review of legislation and judicial review of executive action in habeas corpus than democracy. And I wondered what you thought about that. Guantanamo Bay today, Eric's book ends with a protest. I mean, and tell me, Eric will tell us if I'm right, but I think we're still at the point we were in 2 years ago when Donald Trump just abandoned Barack Obama's effort to close Guantanamo Bay, announced that it's a legitimate and necessary facility for the country to imprison bad guys outside the United States in conditions controlled by the American military. And I assume that there's still about 40 men there. But even before Trump, Barack Obama's government was defending detention against petitions for habeas corpus, while he was also trying to find ways that were politically manageable and effective to get them out of that prison into countries that would accept them overseas. Here's what I don't understand, and Eric's book points out that the fact that they're still there reflects an approach of the courts that leaves it up to the government. In the key case, I think, in 2009, a case called Kiemba, the court says, well, the president is trying to use diplomatic methods to find places for them to be released to overseas. This is a prisoner who poses no risk to the United States of America. And we don't even have power to interfere with him. We have to leave it to him. And of course, today you have to wonder, here's one of my questions for Eric. Why aren't there more proceedings, or have there been more proceedings now that the president is actually disclaiming any effort to get them out of the prison? But secondly, what happened to the legal need in a habeas corpus petition for an accounting by the detainer of the lawful ground for imprisonment? How did the American courts lose that? And where is it? Is there a doctrine that it's lawful to detain aliens outside the United States if the commander-in-chief sees fit? I just don't understand what's happened since Boumediene. There you go. I want to mention finally, briefly, habeas corpus in this case, in this country, it's very unusual for reasons that fits in with Eric's functional approach. you don't need habeas corpus generally because there are legislative schemes for all the important aspects of executive detention, such as mental health, police, pretrial detention, immigration, etc. There are statutory forms of securing justice in executive detention without habeas corpus. But occasionally you need it. And there's a wonderful case from 2012 called Rahmatullah, concerning a detainee in Iraq whom the British had handed over to the Americans. And years later, lawyers for Rahmatullah go to the English courts and ask for habeas corpus against the Foreign Secretary of the United Kingdom. This man's being detained by now in Afghanistan because the British hand him to the Americans take him to Afghanistan. And lawyers for Mr. Rahmatullah go to the court and goes up to the Supreme Court and say, issue the writ of habeas corpus, please, because then the Foreign Secretary will have to get the guy back from the Americans. And wow, the English courts issued the writ of habeas corpus in respect of a person being detained, a person who was not British being detained by the Americans in Afghanistan. And the British Foreign Secretary wrote a polite letter to, I guess it was to Hillary Clinton, saying, can we have this detainee back? We've got to try because there's been a writ of habeas corpus. And lo and behold, the Americans did not deliver Rahmatullah to the British. And at that point, the Supreme Court of the United Kingdom said, well, what can you do? You know, we've done all we can, and we've done a good thing. We've held the executive of the United Kingdom responsible for its own approach to dealing with a detainee that the British had handed over to the Americans. Now, there are just two things that I wanted to point out about the Rahmatullah case. First of all, what's special about habeas corpus? Something I mentioned earlier, there's this special thing about habeas corpus. All the other measures for control of executive detention that are in Eric's book, torts, the fact that it's a crime to detain a person unlawfully, and in this country, a declaration under the Human Rights Act that Article 5 of the European Convention has been violated. All these things were worthless for the purpose of the litigation in the Rahmatullah case. But habeas corpus, you see what habeas corpus gives you, and this is functional in Eric's term. In the Rahmatullah case, it gives you an order that forces the Foreign Secretary of the United Kingdom to go and talk to the Americans. There was no tort. You can imagine a declaration under the Human Rights Act that a right had been infringed. But the writ of habeas corpus made them go looking for the body. And that's a remarkable function that habeas corpus has. And then finally, I just wanted to point out, Eric mentioned that British lawyers helped in the Boumediene case, trying to give an account to the American judges in the Supreme Court of the United States of the heritage that the Americans had adopted from this country. But if you want my opinion, there was no precedent in English law, a whole 1,000 glorious years of English law. No precedent for the proposition that an alien detained overseas can get habeas corpus until Rahmatullah. Until the Rahmatullah case, and in the Rahmatullah case, not even argued. Nobody mentions it at 3 different levels: Divisional Court, Court of Appeal, Supreme Court of the United Kingdom. Never mentioned, just assumed. I think that reflects a good approach. I can't see any reason why the nationality of the detainee or the place where they're detained should have any relevance. But there's no authority, in my view, for that proposition that those matters have no relevance until Rachmatullah. I'm not saying that all detention should be subject to habeas corpus. I don't think that a detention on a battlefield should be subject to habeas corpus. If the judges cannot properly carry out the inquiry, cannot properly issue a remedy, they shouldn't get it, they shouldn't interfere. And maybe that's the answer to the question about Guantanamo detainees today, that the American judges have decided we can't effectively judge or we can't effectively give a remedy. I think that would be mistaken in respect of Guantanamo Bay. But I think it's really interesting that the English judges, that the counsel for the government didn't even try that. Counsel for the government, for the foreign secretary didn't say, well, come on, he's not British and he's not detained in the United Kingdom, so he doesn't get habeas corpus. They didn't even try that, which I think is an interesting reflection on the British judges' approach to habeas corpus. But I don't think that the British judges today would issue a writ of habeas corpus in respect of a detention authorized by statute. So we're not quite there. That's my sense, Eric. Thank you.
Thank you. Let me say a couple of words, and then I do want to give time to the participants. I know I can tell Kate that we don't want to monopolize this to the exclusion of the participants. Let me try to, because there's a great deal in what you said, and I think we're basically on the same page on pretty much all of it. Let me try to group it into sort of three buckets, from the most theoretical to the most practical. On a theoretical level, and that Blackstone retreat to the proposition that a judicial power over legislation would be subversive of all government. That's what they said in America. And Alexander Hamilton said, you misunderstand. The power comes from the people. And that's where the judges get it. That's where legislature gets it. And so when we enforce the will of the people, we are not asserting a judicial supremacy over the legislature. We are telling them that they have misunderstood the directions from our common master, the people. And obviously the conceptual issue over there is, well, is it Parliament that's supreme, or is it the people in Parliament that's supreme? And that's the theoretical question at the heart of all of this. But that precise objection and that precise move was made on our side. Okay, two, sort of the tension between democracy and republicanism, and this reflects what I briefly alluded to about separation of powers and the very idea that separation of powers and checks and balances are different. There is what we have is a republican form of government, not a democracy. The people don't always get what they want. And the Bill of Rights is a series of situations in which the majority does not get what it wants, and the judges will enforce that against the political branches. And of course, at the end of the day, they're doing that at the sufferance of the people. As Learned Hand very famously pointed out, if the Constitution has died in the hearts of the people, judges can't save it, because it's only the self-restraint of the democracy, it's only the self-restraint of the majority that inhibits itself through the Bill of Rights in saying that there are some areas in which unchecked majority will is no good. And so, as you rightly said in your piece about Guantanamo Bay, what we had in the Guantanamo cases was habeas corpus functioning as an instrument of checks and balances. Control over the democratic process in the interest of individual liberties, which of course we believe is in the long run the good health of a flourishing society. But in a one particular day, yes, the will of the people does not get asserted. Okay, so finally, the unfortunate and unhappy practical realities about really making habeas work, and the emotional power of the great writ of liberty comes with a lot of oomph, and that's nice, but what you should see is a guy walking out of the front door of the prison into the loving arms of his relatives, and you sure haven't seen a lot of that. And I guess all I can tell you about the current status of the Guantanamo Bay cases is we are continuing trench warfare in the lower courts. The Supreme Court is not likely to be very receptive, as was seen by their turning aside the Kemba case, which was a great loss, because yes, in fact, they should have been able to walk out. And at the end, just like all that you can, after your smashing victory in Ratmula, do is get a nice letter from the foreign secretary and a nice response to the Americans that say, your letter received no. There really are effective restraints on the power of the judiciary to enforce what it wants without public support. That's why President Jackson said John Marshall has made his decision, let John Marshall enforce it. He doesn't have an army. And so, at the end of the day, I will stop, Kate. At the end of the day, all of this really depends on the power of an engaged public.
So thanks very much to both of you. We've got a couple of questions in the chat window, which I'm going to put from my position as chair. So one is to Timothy, which was really just to follow up on the question of the Rahmatullah case, which you spoke about, and to confirm whether indeed Mr. Rahmatullah was from Pakistan and whether you know the answer to that question. Secondly, there's a question from my colleague Leora Lazarus, the head of research at the Bonavera Institute, who I know battles with her internet. And her question is this. She says, the discussion seems to be detached from the broader national security frameworks, which have been in place since 9/11, both in the UK and in the US, and of course more broadly across the world. Specifically, she says, the push to protect secret intelligence appears to have contorted the substance of habeas in the US jurisprudence and the shape of the legislative responses. And it's also the case that the UK still protects limits on full disclosure and liberty regarding cases. So this is an important element of the context. Eric, any thoughts on that? And after you, Timothy?
Yes, your colleague is entirely correct, and it goes to Timothy's point about what is the status of the requirement that the jailer explain the cause of the detention. Answer, what I think has been in most cases an absolute charade of my God, this is incredibly classified and national security depends on it, which in many cases in practical effect means in any country in the world, if we tortured you, you come to court and complain you were tortured. In the United States, if we tortured you, you can't complain. That's classified information. That's an interrogation technique. And you may wonder how the prisoner is bound by restraints on the disclosure of classified information, and so do the rest of us. But the prisoner can't disclose the classified information about the details of his torture in the interest of national security. And so, yes, there's no question that your colleague is quite right. The distortion of anything resembling law or legal principle since 9/11 has been highly regrettable, to say it in polite English terms.
I don't know Yunus Rahmatullah's whereabouts today. I understand that's right, that he's a Pakistani captured by the British when the British went into Iraq, invaded Iraq with the United States, and handed to the Americans under a memorandum of understanding, which his lawyers would many years later use in the English courts to support the claim that the Foreign Secretary was in control of his detention after he'd been handed to the United States, because there was a memo of understanding in 2003 that said that the British could get a guy back if they handed him over to the Americans. That MOU also said the Americans wouldn't take him out of the country without talking to the British, but they immediately put Rahmatullah on a plane to Afghanistan, I think in breach of the memorandum of understanding. Now, the wonderful John Law is a brilliant constitutional law judge who has recently died, a great man. He was the judge at first instance in the Rahmatullah case, and he said, come off it, the British government is not in control of this detention. I'm not going to issue a writ of habeas corpus to get him back, because it's patent, it's obvious that the defendant in this petition, the Foreign Secretary of the United Kingdom, is not the detainer. He's not in control of the detention. But the Court of Appeal and the Supreme Court were well, either more idealistic, or they thought it was a genuinely open question, and so they issued a writ of habeas corpus that required the Foreign Secretary to ask a question of the Americans to which there would never be an answer. So remarkable, you might say remarkable effort by the appellate judges in the UK to stand up for habeas corpus, even when it was obvious that it wasn't going to work, I think.
Yeah, interesting. Eric, there's another question for you, which is about your reliance on the supremacy clause. And the questioner has asked whether, in your opinion, the supremacy clause merely restrains Congress's ability to suspend whatever habeas jurisdiction is currently in statutes, or whether it is in fact can be seen as implying an affirmative right to habeas review.
Yes, rewriting the question slightly to refer to the suspension clause rather than the supremacy clause, which I think is what's meant. I think the plain implication of the Boumediene case is that, yes, there is an affirmative right regardless of statute, unless Congress has gone through the very difficult and never, in fact, invoked process for a suspension. That's exactly what they held. They held, we have the right to conduct a habeas corpus inquiry, notwithstanding the absence of statute. And I celebrate that outcome. And so I think that the answer to the question is, yes, there is that implication, and that is a vindication of what counsel argued to John Marshall, citing Bushnell's case about the juror who was imprisoned for refusing to convict William Penn of unlawful preaching on the streets of London. That was a good day for the US Supreme Court. And so I think the answer to the question is yes.
Great. All right, I'm just wondering whether there's anybody else who's got any questions. This is the moment to either raise your hand or let us know that you want to speak, because we are coming to the end of the session, but if there are any more questions, I would like to catch them before we finish. Okay, it looks like we've come to, I'm just checking, there seems to be one more new message in the chat box. So there's, yes, I think we've actually dealt with that. Oh, there's a question here as to whether a comment you made about Rahmatullah's case not being mentioned after, perhaps that may mean cited in jurisprudence after it, and whether you think that it will continue to have life in the principles set in Rahmatullah will continue to have life in the British courts. Timothy, you can probably see the question on your chat. Do you want to respond to that?
I'm sorry, I'm so inept, Kate, that I don't know how to look at the chat, but oh, hold on, there's a button to click. There we go, good.
Yes.
Well, Rahmatullah is authority for the proposition that you can get habeas corpus against the British government when they're not detaining somebody if there's an open question as to whether the British government might be able to secure the release of a detainee. That's remarkable. And let's hope that it's not going to often be very useful to litigants. I mean, the other aspect of Rahmatullah that I mentioned, which is of enduring significance, is that I mean, they don't even say this, but it is presupposed at all levels in the decision that the nationality of the detainee makes no difference and the place of detention makes no difference. Now, I think that means that the British courts have some more work to work out whether there are any limits at all on detention, on habeas corpus in respect of detention during military operations overseas. This is an open question, and it's connected with some very difficult questions about the jurisdiction of the European Convention on Human Rights. It's work in progress, but habeas corpus has been a work in progress since the 12th century, and it still is.
Okay, well, thank you very much to all of you who have attended, and particularly warm thanks to our presenter Eric Freedman and the respondent Timothy Endicott. We're very grateful to them for being willing to participate in this remote proceeding of the Bonavera discussion group. And just to remind all of you that who are present that there is a series of online seminars taking place both through the Bonavera discussion group series, which takes place at Tuesday lunchtimes Oxford time, and also through our network series on Wednesday lunchtime. So please keep an eye on our website to see if there's anything else that interests you. And we're always would be open to any suggestions for things that people would like us to pursue in the discussion group as well. And meantime, to wish you all well and to keep safe in this difficult time. And again, to finish off by thanking our two presenters for a really interesting seminar. Go well, everybody.
Thank you so much. And as I'm sure you'll be hearing at the end of the week, we will meet again.
Thank you, Eric. Thank you, Kate.
Good. Thanks then. Bye, everybody.